Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I wanted to do a video about damages in New York, and it also applies to damages all over the United States of America. How much money can a victim receive after a serious personal injury, and what are damages all about? I recently did a continuing legal education known as a CLE in New York, and it was an annual update. So it was the entire year of 2023 and what happened with respect to damages. Damages are amounts of money that juries, usually juries, allow for after a trial is over. So let's get into it. So first of all, they started off by talking about the Seventh Amendment and the fact that the New York Constitution in the Article 1, the Bill of Rights, and Section 2 gives the right to a trial by jury. Just as the Seventh Amendment says, in suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved. And so then they kind of talked about CPLR, which is the Civil Practice Law and Rules. That's the statute and basically the basis for procedure. When you do a trial, you have to follow the CPLR, right? So the Civil Practice Law and Rules in Section 5501C, what it basically says is that a jury verdict will not be set aside. So this idea of the Seventh Amendment, this idea of trial by jury, we give a lot of deference to it, right? And we follow whatever the jury does. Because in a trial, the jurors, in New York, we have 6 jurors, they make the decision. And those jurors are the triers of the facts, meaning they decide the facts of what happened. And we give a lot of deference to them, and we don't set aside their verdict unless it deviates materially from what is reasonable compensation. So with respect to CPLR 5501C, there was a case known as Quijano. And in that case, the court said, although the amount of damages to be awarded for personal injuries is primarily a question for the jury, a jury's award may be set aside if it deviates materially from what would be reasonable compensation. And so the question becomes, what is reasonable compensation, right? So in the pattern jury instructions, now this is a book, it comes out every year, and it's known as the PJI, the pattern jury instructions. That particular book says that the jury must render a verdict in a sum of money that will justly and fairly compensate the plaintiff for all losses resulting from the injuries and disabilities he or she sustained. And aside from general experience, there is no legal criterion to guide jurors in translating into money values such intangibles, such as pain, suffering, and shock. And that's a comment to the pattern jury instruction, specifically 2:280. So essentially that becomes the trial lawyer's job, right? The lawyer you have, that becomes his or her job to translate into money values and intangibles like pain, suffering, shock, fright, emotional distress. And that's kind of what I've been talking about in a lot of my videos. If you've been watching my prior videos, I talk about the fact that you have to look at the damage to the person. And it's not only that person, but it's the entire life. So you have to do a biography. You have to find out if they have children, if they have a wife or a husband, their friends, people in their job, their community, their neighbors, whatever's important to them. It's really life, liberty, and the pursuit of happiness, what they were like before and how their life has changed after. So you really have to do a deep dive in order to really show a true picture of how this individual's life has changed. And that's kind of like what the reasonable compensation, right? There is no formula, there is no legal criterion. So then they talk about damages in jury trials, and they talked about CPLR 4016B. And what this does is it allows an attorney to refer to a specific amount for any element of damage that is sought to be recovered in the lawsuit. So that means that you can ask for a specific amount. For example, past pain and suffering. Past meaning from the date of the crash or the incident up until the date of the trial. And that could be, for example, $500,000, right? Then future pain and suffering from the date of the trial up until the rest of this individual's life, depending on the life expectancy tables or averages of how long they're supposed to live. They might have 40 more years to live. So you can say based on 40 more years of life, we ask for a future number of $1 million, right? So you can give specific numbers for each category. Now, it doesn't say, the examples they gave in this continuing legal education were things like past pain and suffering, future pain and suffering, past economic loss, future economic loss, including medical bills. But they didn't talk about more, you know, if you really dive into it and you read the pattern jury instructions, within pain and suffering, you have subcategories. For example, you have pain, you have suffering, you have shock and fright, you have emotional distress, you have mental anguish, mental suffering. So you have disfigurement, for example. So can you ask for, you know, a different amount, like a line item for all of these different amounts? I think you can probably ask for it in your closing, because this refers to closing arguments, opening and closing statements, this 4016B that we're discussing. So you could probably mention it in your closing, but then the judge will also say that anything you say in your closing is, you know, summation. So it's argument, it's not evidence. And when they do give the sheet to the jury to fill out to award the amount, that sheet will not have all the subcategories. It'll just say pain and suffering, right? All the subcategories are like subsumed within pain and suffering. I don't think you can get, you know, that would be better for a plaintiff, right? Because you can get shock and fright, mental anguish, emotional distress. You'd have all these, and you go, give me something. But if you add everything up, it's going to be obviously a higher amount. But I don't think that that's going to be allowed. But anyway, but the PJI basically says that it has to be full and fair compensation, not 1 penny more, not 1 penny less. And there's no prohibition on anchoring. Anchoring refers to, for example, you know, referring to a specific amount, like saying that the law and evidence in this case is going to justify a verdict for $10 million. And then you say that in opening, then in closing, you go back and you say it's going to be $10 million. And now you've anchored that in the jury's mind. So they're going to say, well, is it really worth 10 million? Oh, well, 10 million's a lot. Probably not worth 10 million, but okay, how about 5 million? Okay, we all agree to that. Yeah, it is really serious. It is really life-changing. Let's give 5 million. And you see, you use the anchor of 10 million to get 5 million, which is still a big amount. And some courts have said that anchoring is not allowed, but in New York, there is no prohibition on anchoring. And in the same vein, the defendants, the insurance companies and the defense lawyers, they have this idea of nuclear verdicts. And it's a term that was popularized by the insurance industry and lobbyists. And the definition is really any verdict that's greater than 10 million, I guess like an 8-figure verdict. And so the solution to avoid 8-figure verdicts, don't kill or maim people, right? Be safe. Big verdicts, the trick to big verdicts, according to this CLE that we did, was to empower the jury as gatekeepers to enforce safety rules and balance the harm, because the jury is really like a member of the community that is a gatekeeper. They're telling you what the safety rules are, what the safety rules should be, and to balance the harm, right? It's the equal trade dollar value for all the harm. So if you commit a serious harm to a person's life, like you take away their life, you take away their child's life, you injure them to the point where they need a spinal fusion, right, or serious spinal cord injury, they're paralyzed, they lose a limb, like lost, like an amputation of a hand or a leg, something really, really drastic and life-changing, something terrible like that, well, then you're going to have to pay $10 million or more. So, yeah. So then the other part that they talked about was this Wrongful Death Grieving Families Act. And that's actually a new law that's on the governor's desk, but it hasn't been signed yet. So it's awaiting signature. And the problem was that the current law is from 1847. And this is the law on wrongful death. So the problem with the law is that it ignores the losses of loved ones. So if someone is killed, let's say a father of a family is killed, it'll allow for the pecuniary loss, the monetary loss, like the father's income, but it won't allow for like loss of love, loss of companionship, loss of guidance to the other people. It's more of an antiquated law. And so this new law allows for the recovery for the losses of loved ones and companionship, and it includes damages to survivors for loss of services, loss of support, loss of guidance, and it's not limited to spouses and children. So hopefully the governor signs this law. It was already supposed to be passed before, but it got vetoed, but now I believe we're waiting on it, so we'll see. So then the next thing was they went into some cases, some actual cases, and a lot of the cases had to deal with wrongful death or medical malpractice. Here was a case, this case was known as Stewart. So Stewart was a case where it really illustrated the example of the Grieving Families Act. So it was an individual who was 73 years old. He was discharged from a hospital despite having very high levels of leukocytes. So he returned to the hospital because this leukocyte level kept rising, and he had like confusion. And then he ended up passing away. He died 28 days after the initial admission because he had bacterial meningitis and a mucotic aneurysm. And this was all left undiagnosed. So the hospital was found liable. It was a medical mistake. And 1.3 million was sustained by the appellate division. This was the jury award of 1.3 million for his past pain and suffering. But then because of the current law, there were no wrongful death damages. He's 73, he's not working. And then what about the wife and son and all of their damages, their loss of love, loss of companionship? That was worth zero. So that's an example of how the current law is not working. And then another case they talked about was Appleyard. In this case, a plaintiff underwent surgery for a torn meniscus. That's a part of the knee, a ligament that got torn. And 1 week later, he was diagnosed with MRSA, which is a really bad infection. And he ended up suffering kidney damage due to improper monitoring that led to acute kidney failure that required dialysis for 3 days, 5 days of blood transfusions, and resulted in permanent kidney damage. And a Manhattan, that's New York City, Manhattan jury allowed for $3 million for past pain and suffering, even though it was only 3 weeks, because these damages are so egregious, so horrible. But what happened was the first department, that's the appeals court, the higher court, they said that although none of the cases relied on by the parties are squarely on point, the subject award is well outside the range of awards in all of these cases. So I guess they looked at like the common law precedents. They said in this type of case, that's just too much. And they lowered it down to $500,000. That's all they allowed for in terms of damages. So they cut $3 million down to $500,000. And here's another case, medical malpractice, Unwin. In this case, there was a catastrophic injury to the right hepatic bile duct during what should have been a routine laparoscopic surgery. And so it was a $5 million verdict and $4 million in pain and suffering. That was what the testimony at trial said. And then here's another case. This one was just a regular car crash. Plaintiff was a passenger, and it's called Petite versus Archer. Plaintiff was a passenger on a New York City Transit Authority bus and was involved in a crash, and plaintiff needed a cervical discectomy infusion. The verdict was for $4,425,000, and it was broken down as $600,000 for past pain and suffering, $1.5 million for future pain and suffering, $525,000 for future lost earnings, and $1.8 million in future medicals. And the appellate division, again, the appeals court, when they examined whether this deviated materially from what is reasonable compensation based on other cases, they said that they lowered it, but they still kept it, but they lowered it from $4.4 million down to $3.3 million, specifically $3,329,760. And they essentially said $600,000 for past pain and suffering, they kept that, that's fine. $1.5 million for future pain and suffering they thought was too high, they lowered it to $1.2 million. They shaved off $300,000. $525,000 for future lost earnings, they cut down to $396,000. And $1.8 million in future medical expenses, they cut down to $700,000. And their rationale was basically, they said future special damages, that's like the future damages for the medical costs, right? The fact that I'm going to need of future surgery, future prescriptions, future physical therapy. But when you add all that up over the course of someone's entire life, it could be a big amount. But they said these future special damages cannot be speculative. The award for lost earnings must be reasonable and be supported by the evidence. The awards for damages for past and future medical expenses must be supported by competent evidence, which establishes the need for this medical care, the cost of this medical care, and so you have to have doctors, you have to have economists, and it can't be speculative. So, I didn't go into the details of that particular case, but we could look at it maybe in another video to see why it was speculative in that case. Here's another case. This one involves an ankle injury. It's known as Caruso, and this is from Nassau County on Long Island. And what they found in this case was it was a fall from a ladder, a construction accident, labor law 240. And there was a right ankle pylon fracture, external fixator, and ORIF, open reduction internal fixation surgery. A $2 million pain and suffering verdict was upheld by the trial court, and future damages were reduced. Future special damages, like the medical expenses, were reduced because they were speculative. So I guess here too, they thought that it was speculative. And then they talked about this benchmark case, which I think I did a video on this before. It's a traumatic brain injury case known as Perez versus Live Nation. That's a case from 2021 in the First Department. And what essentially happened was the plaintiff was working at Jones Beach in the theater, and he was setting up a booth for a concert when a forklift crashed into that structure he was setting up, and it caused him to fall 10 feet, and he fractured his skull. He had a severe traumatic brain injury, cerebral atrophy, traumatic epilepsy, chronic pain, headaches, significant cognitive deficits in attention, processing speed, memory, visual perception, intellectual function. He really had a severe brain injury, and it was very, evident. It wasn't like one of these mild traumatic brain injuries where you have to get a neuropsychologist to explain what the difference is. It was like really evident. This person had a brain injury. So the jury allowed for $10.5 million for past pain and suffering and $75 million over 43 years for future pain and suffering. So the total amount was $85 million just in pain and suffering, right? 10 plus 75. Actually, it was even more. It was 85 plus another million, because it was 10.5 and 75.2. So it was like 85.7, almost 86 million just in pain and suffering. So the Manhattan trial court, this was a Manhattan trial, they reduced the future pain and suffering award to 30 million. And then the appellate division, First Department, which is the appeals court, that's usually the final say unless the case gets certified to the Court of Appeals, but that's rare. So usually the appellate division is the final say. What they said was even 30 million is a lot, and they reduced the past. So they said 10 for the past was a lot. So they said for the past, take 5, that's sufficient, and for the future, 15. So the total was 20 million. So instead of 86, it was 20. But it's still considered one of the highest amounts. It says here, even with the reduction, this represents a significant upward trend for this type of injury. So that's good that at least the trend is going up, even though they're cutting the verdict pretty significantly. If the juries think it's worth 100 and they're giving 20, they're cutting it, that's a lot. They're cutting it and dividing it by 5, but it's still an upward trend. And then there was another traumatic brain injury case in 2023, and this one was known as Lee. And this is an interesting case. I might also have to do a separate video about this case. But what happened here was there was a rear end car wreck with a concussion and a traumatic brain injury. And so the trial was in Dutchess County, which is upstate New York, a little bit more conservative. And the trial was about damages only, not about liability, because it was a rear end, so they won on liability. And they had evidence of the traumatic brain injury from doctors, from the family. And the defense attorney, in his closing argument, he said the plaintiff's case was a conspiracy with doctors and was fabricated like the Wizard of Oz. And he said that the plaintiff greased the levers of the lawsuit machine, and that he wanted to give them a knockoff Academy Award for a performance in faking an injury. And this resulted in a modest jury verdict. The verdict was only $117,000 for this brain injury, whereas so the other brain injury was $100 million. This was $100,000 because this defense attorney was doing these saying this was all fake and saying all these outrageous things. So the appellate division, or the, it wasn't the appellate division, but it was the court, I think it was the trial court, they had post-trial motions, and the court said that these remarks by defense counsel were reprehensible, just terrible and not allowed, and they set aside the entire verdict, and the trial is going to have to be conducted all over again. So this is an interesting case. Maybe I'll get the file, the trial transcript, and I'll read it, and we could do a video about this, because this is kind of like one of the things that these defense lawyers do, right? These insurance companies, because they don't want to pay money, they don't want to pay fair value for real injuries. They make up this stuff like, oh, this is the Wizard of Oz, you won an Academy Award, and this is all fake. And basically they're saying that, and they use this idea of lawsuit abuse. You know, do you feel like there are too many frivolous lawsuits? And they did that in voir dire. So right from the beginning, when they were selecting a jury, the defendant said, do you think there are too many frivolous lawsuits? Is there lawsuit abuse? And, you know, the conservative jurors maybe said, yeah, we think that. And then he left them on the jury. So the plaintiff's attorney, I don't know the details, but the plaintiff's attorney maybe should watch some of my videos and how to deal with that, because there are ways to deal with that and to get a fair jury. Okay. And then the next category were amputation cases. And these, of course, are also very, very serious injuries. So there was a case, Ortiz versus National Grid in Brooklyn, where the verdict was $24,750,000 for a bilateral below-the-knee amputation. So that means the amputation was lower than the knee, but both legs were amputated. And in Firms versus Chase Manhattan, the Second Department Appeals Court, there was a $5 million pain and suffering verdict, and the plaintiff was involved in a motorcycle accident. He had to have 11 surgeries and lost his leg below the knee. And I believe the $5 million was affirmed. It was allowed to stand. And in Aguilar, that was a First Department case. It was an older case, and it actually set a record back then. It was in 2011. It set a record. There were 10 surgeries. There was an above-the-knee amputation, and it was a $10 million pain and suffering verdict that was allowed to stand because of the severity of that injury. And then in an asbestos case, which is mesothelioma exposure, known as Scene versus Kaiser. This was a New York County, Manhattan trial in 2023. The trial was in New York County. The defendant failed to warn the plaintiff of a hazardous joint compound which contained asbestos and caused mesothelioma, which is a terrible cancer. So the plaintiff suffered for 43 months and then was killed by mesothelioma. And the jury verdict was $15 million. It was essentially $348,847 per month. And that was not a basis for remitted, or meaning not a basis to do the trial all over again. That was fine because of the injuries being so serious. Okay, so I hope this was helpful. I think that's pretty much all the cases in this damages update that I was going off the PowerPoint slides that they provided to us. But like I said, some of the cases are interesting, like that case where they called the guy a faker or a Wizard of Oz. Maybe we could do a deeper dive. I'll try to get the trial transcript and read that case, and then we could talk about it if I find anything interesting in there. And let us know what questions you have. I mean, damages are essentially how much somebody can obtain for their pain and suffering, whether it's a truck crash, a car accident, a bus accident. And then it really depends on the injury, right? The injury to the person, the overall damages. But you see how they think about it. They think about it as pain and suffering from the date of the incident up until trial. That's known as the past. And then pain and suffering from trial, and then for the rest of your life, and that is known as the future. And subsumed in pain and suffering are, of course, the conscious pain, the suffering of that pain, living with the pain, the disability, the shock and fright, the emotional distress, the mental suffering, the disfigurement, if there is a disfigurement like scarring. All of these things are subsumed and a part of pain and suffering. But what I like to do, like I said before at the beginning of this video, is not only give the medical evidence, but also give the biography to explain who the person is, what their passions are, how their life and their family's life or their close circle of friends, right? How that entire ecosystem of someone's life has been affected, how it's been destroyed and damaged. So I think that's very powerful. And that lets the jurors like empathize with you, right? And see like this, just a human feeling. Because remember, there's no formula, right? It's just based on people's common sense and general experience. And people have experiences. Everyone's living life. everyone could see and empathize with how someone's life has been changed, and then allow for a big amount of compensation, which is the equal trade dollar value of all the harms and losses, everything that was taken. Okay, I hope this was helpful. Let us know what questions you have and what videos you want to see. Okay, we are here for you. Have a great day. Please like and subscribe to our channel. Let us know what questions you have. Drop us a comment. We read the comments and then do a frequently asked questions video discussing the comments. We also sometimes do live frequently asked questions where you could go live and ask me a question directly, and that's known as Last Week Tonight, where we go through all the comments in the last week and we talk about it. And also Last Week Tonight Live, where you can join and just ask a question live, and we'll probably do one of those later this week as well. Okay, have a great day, everyone. Bye-bye.